So, 1803 Marbury versus Madison, this is just cited as a case that's popularly associated with the origins of judicial review, but it certainly didn't begin here. So what is judicial review? It's a superior court's examination of the conduct of an inferior court, board, committee, or tribunal to ensure the conduct was proper in law. This is distinct from an appeal, and I'm not sure exactly how it is distinct. I know that appeals can be brought on questions of fact, or questions of law, or questions of fact and law, and it might have something to do with that, but it relates to the superior court's function, a limited legislative review, and also review the conduct of all inferior courts, boards, and tribunals. And it's conferred on provincial superior courts. So, the history of judicial review began in the English royal courts during the writ system. There were the writs of certiorari, mandamus, and quo warranto, and when those writs were exercised, the inferior courts were to certify their record for review, or they were asked to do a certain act, or the eligibility of an inferior court office holder might be challenged. During early British North America, the courts rejected this power and left it to the Crown's power of disallowance. Eventually, though, disallowance became politically unacceptable, especially it was used a lot during early Confederation when the colonies' governments thought they were omnipotent and were enacting a lot of legislation that was unconstitutional. Nevertheless, over time, the provincial governments grew weary of protesting the federal government's use of the powers of disallowance, and the federal government was getting tired of being criticized all the time for using it. So, judicial review replaced disallowance and created a more objective and less, I guess, political conflict, I suppose, when it came to examining the decisions of the inferior courts and the legislation of the provinces. So, because it was up to the judiciary, if something was unconstitutional, then they had no problem striking it down. And the legislatures eventually wanted some of their legislation to be excluded from the judicial review process, mostly so that they could infringe on Section 96 courts in order to make efficient tribunals. And this is, of course, unconstitutional. But they tried. So what they did was they created privative clauses that said that the decisions of these certain specialized tribunals are not subject to judicial review. And in Crevier versus the Attorney General of Quebec, we see one such example. So it was with regards to the Professions Tribunal, and they heard appeals from 38 different professional organizations. The tribunal had 6 judges who were from the inferior court, and the legislation that created this tribunal said that the professional code, which presumably was legislation, declared their decisions final and not subject to appeal or judicial review. Crevier was a person who brought a complaint to the discipline committee regarding some optometrists, and they appealed, and the profession tribunal, which hears the appeals from the discipline committee of the professional organization, found that the committee had exceeded their jurisdiction and dismissed the complaints. Crevier, unhappy with that, applied to the Superior Court, and they granted orders of judicial review because they found that it was possible that the powers of the tribunal offend Section 96. So, do the powers conferred on the professional tribunal violate Section 96? No, they don't. They were perfectly allowed to have a professions tribunal. But does the privative clause excluding them from judicial review violate Section 96? Yes, it does, unequivocally. So the province cannot legislate Section 96 powers on a tribunal or exclude them from judicial review, which is essentially what they're doing. Or they're essentially legislating 96 powers on the tribunal by excluding them from judicial review. However, the court does recognize the need to have superior courts which serve the legislative policy and interests of adjudicative agencies. And so, it is the case now that superior courts won't necessarily review the decisions of administrative tribunals, but they absolutely will review their jurisdiction. That last statement is possible, I'm not certain on that. So, moving on to delegation. The federal and provincial government would obviously like to cooperate on some matters, but it's difficult due to the exclusivity of Section 91 and 92. And from what we've just seen, they obviously can't insulate tribunals from Section 91, 92 limitations, nor the exclusivity of the powers of Section 96 courts. So, this is the solution they came up with. This is what we're going to be going through for the next little while. But there's vertical, horizontal, and diagonal delegation. And what the government ended up doing was making a distinction between legislative delegation and administrative delegation. Legislative delegation is transferring the power to legislate on a certain matter. Administrative delegation is transferring the administrative power to a person who is perhaps employed by the province as well. If it's Parliament that is delegating those administrative duties. So vertical refers to kind of the hierarchy of governmental powers. So is vertical legislative delegation allowed? It is to the executive branch. So the Lieutenant Governor or the Governor General makes regulations which are adopted by the executive and brought in by proclamation. So this is the legislature, the provincial legislature, delegating the legislative powers to create regulations which are then adopted by the executive from the provincial legislature to the Lieutenant Governor and the executive branch. And that type of vertical legislative delegation is allowed. The issue of delegatus non potest delegare, we'll cover in a second. Delegate cannot subdelegate. This issue put the delegation between the Parliament and the provincial legislature as horizontal. They are considered equals in the eye of delegation, I suppose. And they're not allowed to delegate legislative powers between each other. The exceptions are if the Constitution gets amended, or they can create conditional legislation, which is kind of the halfway point between legislative delegation and administrative delegation. And diagonal delegations would be the federal government giving legislative power to the Liquor Control Commission, and that's not going to happen. What is allowed, however, is administrative delegation. So the non-legislative authority from Parliament and provincial legislature can be delegated to administrative bodies, and this happens all the time with the creation of all types of specialized tribunals, the Island Regulatory Appeals Committee, Health PEI, et cetera, et cetera. Horizontal administrative delegation happens in the form of conditional grants, where the federal government provides millions or billions of dollars to the provinces on the condition that they implement certain legislation. And sometimes this is a form of centralized power, and other times it's a form of accommodation. An example would be Chrétien's conditional grants for labor development was something that the province wanted that they couldn't do through other means. Lastly, administrative delegation diagonal is the federal government delegating administrative duties to a person or committee that is in the province and has already been delegated certain duties by the province. So this committee or person is now administrating the powers of the federal government and the provincial government. And it can go both ways. You have a federal government person with federal powers, and all the province delegate to that person certain authority. So these are the solutions. We're going to go through each one. Okay, so delegatus non potest delegare. This is the transfer of legislative power from one jurisdictionally competent body to another. And it happens mostly with the legislative body to the executive branch to create regulations. And this was argued in Hodge and the Queen in 1883. It was argued that the provinces are delegates of the imperial power, and that they can thus not subdelegate their powers to anyone else. But it was determined that their authority is not as a delegate, but as per Section 92 of the Constitution. And it's also worth noting that, just as a side note, that if you delegate powers to a board, you can revoke those powers. So, one of the cases cited in, or I guess one of the cases that followed it, is it cited? No, followed it, determined that the federal government and the provincial government are equivalent, the Governor General and the Lieutenant Governor are equivalent, and that one cannot enlarge the jurisdiction of the other nor surrender jurisdiction to it. And so this sort of establishes what we have now, where vertical administrative delegation is allowed by the provinces and by the Parliament, but horizontal legislative delegation between the Parliament and provinces is not allowed. And one of the reasons that was cited in this case is that the Constitution of Canada does not belong either to Parliament or to the legislature. It belongs to the country, and it is there that the citizens of the country will find the protection of the rights to which they are entitled. No power of delegation is expressed either in Section 91 or Section 92, nor indeed is there to be found the power of accepting delegation from one body to another. And so the Constitution doesn't belong to Parliament or the legislature, it belongs to Canadians, and we have a right to, I guess, what is described within it. So the Nova Scotia interdelegation case, this was an early attempt at cooperation, I suppose, between the federal and the provincial government. It was a submission to the Supreme Court of Nova Scotia regarding Bill 136, an act respecting the delegation of jurisdiction from the Parliament to the legislature of Nova Scotia and vice versa. So respecting delegation of jurisdiction. Not allowed. But the idea here was that the feds and the provinces wanted to cooperate on a national pension scheme, but the feds were unable to create laws regarding to employment in the provinces, and the provinces were unable to levy the taxes. And it was determined that too bad you're not allowed to accept even temporarily or give up even temporarily your jurisdictional powers over something that's described in section 91 and 92. And the reasons were excellent. So if this bill were intra vires, the Dominion Parliament could delegate its powers to any or all provinces to legislate on any matters: commerce, banking, bankruptcy, militia, defense, issue of paper money, patents, etc. So if this was allowed, there would be no reason for having the different classes associated with section 91 and 92, and those, of course, serve an important purpose of defining our federalism within the country. So the solution. There was a few failed solutions. The Fulton-Favreau amendment. This was an amendment to permit delegation. Some people suggest rewriting the Constitution, or amendments to reallocate the heads of power. So switch some of the matters that are 91 and 92 to the other. And of course there's section 94, where the federal government has the power to make uniform the civil and property laws of the provinces. However, this has never been used, and it probably won't be because it's permanent. So the solution, as kind of showed before, is administrative. Conditional grants, administrative interdelegation, incorporation, and conditional legislation. Conditional grants, we already went through that. Administrative delegation. The case that relates to this is the PEI Potato Marketing Board versus H.B. Willis. The PEI Potato Marketing Board and PEI was created by the provincial legislature by statute and authorized to use for certain powers. Some of those powers were to set the maximum and minimum prices for potatoes in the province, as well as require people selling potatoes to pay a license. However, this was seen as a regulation of trade. However, it was desirable. So the Parliament passed the Agricultural Products Marketing Act and gave the administrative powers of that act to the Potato Marketing Board, thereby expanding their powers to include interprovincial and export trade. So some background here is that in this case, they held that the province could not delegate its legislative powers to the provincial government. It could, however, delegate its administrative powers. So they approved the marketing scheme, the Supreme Court of Canada did, where intergovernmental delegation is administrative rather than legislative. So what this created was both levels of government entering into extensive negotiations to establish marketing schemes whereby the 10 provincial marketing statutes would enjoy intergovernmentally delegated powers. That's about it. That were conferred on them by the Agricultural Products Marketing Act. Great. So that's administrative interdelegation. Incorporation by reference. It's essentially like reception. You incorporate a part of a statute. So the federal basically it says this one's a little more challenging. You can textually, like, take the text of legislation from a jurisdiction and enact it as your own. So, through the use of the doctrine of incorporation by reference, it is possible for levels of government to pass legislation within their jurisdiction, incorporating textually the legislation of the other level of government. And anticipatory incorporation just means that the incorporation of the other